Hello and welcome to Sherayzen Law Office video blog. My name is Eugene Sherayzen. I'm an international tax attorney and owner of Sherayzen Law Office Ltd. And today I'm standing on the border of the United States and Mexico near Laredo, Texas. As you can see, this is the Rio Grande that separates Mexico from the United States. And you can see over there is the fence from the US side separating the border. And what I would like to talk to you about today is how this fence and this border affects the perception of people with respect to their US international tax compliance requirements, and why many of these perceptions are absolutely wrong. You see, a lot of people think that once they cross this river from the United States into Mexico, that their US tax reporting requirements have ended. A lot of people think they're not responsible for anything to Uncle Sam, and this is absolutely wrong. I have seen a lot of examples, by the way, of this, where people think that, well, you know what, I have a business in Mexico, I've crossed that border, I don't owe anything to the IRS. That's not correct. As a US citizen or a US permanent resident who maintains his US permanent residency, that is, he's not abandoning his US permanent residency, you're required to disclose your worldwide assets and worldwide income and foreign assets. So in essence, there are two reporting requirements. One is the worldwide income, that is income that is earned anywhere in the world, whether it is inside of the United States or outside of the United States. That income has to be disclosed on your US tax return, and you have the obligation to disclose your foreign assets on US information returns, as long as you, of course, satisfy the filing threshold. So, for example, if you have foreign bank accounts, well, this means that you need to disclose these foreign bank accounts on forms like FBAR and Form 8938, as long as you satisfy this threshold. If you have a foreign business, well, if it is a foreign corporation, then you will have to disclose it on Form 5471, as well as related forms concerning the transactions between you and the corporation, or certain transactions that the corporation performs. A controlled foreign partnership, then it's Form 8865. And if you have a disregarded entity, then it's Form 8858, etc., etc. Basically, the point being is that if you have foreign assets, you have to disclose them to Uncle Sam, irrespective of whether you reside in the United States or outside of the United States on the other side of the border in Mexico. All of these obligations are very important. They carry significant non-compliance penalties, and you want to make sure that you avoid them. The other important thing to understand is that your obligations to the IRS, once you cross the border, not only will they not decrease, they're more likely to increase significantly vis-a-vis what you used to do while you were here in the United States. Again, this is the rule that applies to US tax residents of any type, whether you are a US permanent resident or a US citizen. If you would like to learn more about your US international tax compliance requirements, you can call me at 952-500-8159, or you can email me at eugene@sherayzenlaw.com. Thank you for watching. Until the next time.